Thank you very much. Good morning, everyone. I did not just arrive. I wish I had. That's awesome. But to those of you who did, congratulations. Welcome. This session is frequently asked questions about IP issues in commercial deals. The sort of high-level goal of this of this session is really just to sort of, at a high level, talk about the kinds of IP issues that in-house lawyers face daily, just to give a sense of, give you enough information about what IP is, when IP issues might be present, so as to sort of arm you to be able to resolve them or, find the right person. Don't worry, this is not going to be a deep dive. We're not going to try to teach you to be IP lawyers, for anyone who's not already, don't worry. But that's sort of the general overview of what we're doing here today. So if you're not interested, now is the time to make a hasty exit. No shame. Okay, so quick introductions. My name is Travis Campbell. I'm a partner in the Austin office of K&L Gates. Anyone who's not familiar with K&L Gates, we're a global law firm of around 2,000 lawyers, around 50 offices all over the world. We're a general practice firm. We have expertise in many areas, but one area in particular is intellectual property, data, those sorts of issues. So my practice in the technology transactions group, a lot of people ask me what that is. At K&L Gates, it falls under the intellectual property department. At other firms, it falls under the corporate department. Frankly, it straddles the two areas. I negotiate deals involving technology in all different contexts. Software deals, pharmaceutical development, drones, satellites, branding deals, website terms of use, you name it, honestly. Any sort of contract that involves some sort of data, technology, intellectual property is generally my practice. So that's me. Jason?
Hey everybody, I'm Jason Chung. I'm at Southwest Airlines, and sort of right off the top, I want to let you guys know I'm not an IP attorney. I did not do patents. I don't do any of that stuff in my background. And so you may be wondering, then why am I up here? But I think it's because I'm like a lot of you guys. I was a commercial litigator by training, liberal arts major before that, but having gone in-house, no matter what kind of company you guys are at, technology is a key part of your day-to-day life. And from if you're selling products, if you're running an airline, it all runs on technology. And so you'll face these issues, I think, on a day-to-day basis. And I've found it to be a way to, even if you don't do it, I don't have background on it, it's something you can learn. And what I think you guys will learn some today will be enough for you guys to add value to your businesses. And hopefully I can give you guys a perspective on some basic diagnostic questions and just some ways about thinking about this stuff that can really help you in your day-to-day practice. And so, we'd love for it to be a conversation as well. So if you guys have questions or just things you want to chat about, and as we go through the slides, feel free to raise your hands and we can bring a mic over.
Yeah, absolutely. Just to echo that, I mean, I think that it's going to be a much more helpful and useful presentation if there are questions. I would be perfectly fine to not get through these slides. That'd be fine. So, as I said, high level, brief overview of IP rights. Again, we're not going to get into patentability here, but a quick overview. So, there are four main buckets of IP rights that you're sort of going to deal with. Those are copyrights, patents, trademarks, and trade secrets. I imagine almost everyone in the room has heard of those, or at least some of those. I do frequently get clients who are pretty confused about them, and more than once I've been asked, how do I copyright my patent? Which for anyone who works in the space knows is not something that you can or should do. But so again, those are the four main buckets. There are some additional ones that some people think of as, well, that are very closely related, rights of publicity, and also data. Now, data's a bit of a weird one because it can be trade secrets. It's sort of proprietary and can be IP. Then you've got sort of personal information, things like that. We're not really going to focus on data so much because the presentation prior to this one was about data breaches, and there's another presentation on data later today, so we won't focus so much on that one. So moving to the next slide. So copyrights. This is the one most in-house lawyers deal with most frequently. Obviously, if you are at a high-tech firm that does a lot of patents, then that's not going to be true for you. But copyrights are works of authorship fixed in a tangible medium of expression. That's the real short answer to it. The most important thing to remember about copyrights is that they do not need to be registered. They exist automatically. If I take out a pen right now and draw a little picture on a napkin, that has copyright right then. Now, nobody cares about that copyright. I'm not going to go enforcing it. It doesn't really matter very much, but the fact is it does exist. So when you are, let's say, the company you work for is engaging a service provider of some kind, you might not be thinking about copyrights being relevant, right? Because a lot of people think of copyrights as books and movies and things like that. But the reality is that when that developer or the vendor is preparing charts and sheets and plans and all those things, those all have copyright, right? You might not care, you might not want to enforce them, you might not want to register them, but there is something there. So it's not the case that there is not IP present or that there are no IP issues. There very well may be. But the thing that I want to get across is that it's there and you should be aware of it, and then maybe you care, maybe you don't, but you should know it's there.
I'll jump in real quick there, Travis. So one way this may pop up in your business, right? You probably have somebody in your business writing code, doing software, making some, either within, it could be something as simple as stuff in an Excel spreadsheet or something much more sophisticated, like they're doing some databases and things like that. And I'm sure some of you may encounter an employee decides, hey, this might be something neat for me to go off and start a business on or sell or whatever. And then you may flip out that, wait, did we have an invention assignment agreement? Did we document that? Just tap the brakes. It's not time to freak out. That's sort of the nice thing about copyright is, there's some arguments you can make, and this is when you call a guy like Travis to figure this out. It's obviously better to have an invention assignment agreement, have an IP policy. If you don't have those things, those are things I think it would be wise to implement. That's another thing you could add value to whatever company you're at. And the outside law firms are really good at helping you think that through. But if you kind of finding yourselves in a bind, copyright is a good piece of law that you can leverage to help maybe save yourself, save your business team from freaking out too much if you're encountering some of those issues.
Yeah, thank you. And as you were talking, I was just thinking, a thing that comes up a lot, I see it very frequently, is in an M&A context where you might be representing a buyer and the seller, they say, oh, there's really no IP involved. The seller is, I think I worked on one, and the seller was a barge company or something, and there's not going to be much IP involved in that. So the corporate lawyers weren't really thinking about that. So they were agreeing to only take ownership of, trademarks and a couple of things, and they were just not going to take ownership of any copyrights because in their mind there just wasn't any. Well, the website is all copyrighted content, right? All the stuff that gets posted on that website, all of the background materials, that's all copyright. Again, you can choose whether you want to enforce it or do anything with it, but as the buyer, you should probably own it. So, you just want to make sure you cover it. So the next one, patents. Probably no need to take too deep a dive here, but essentially, so a patent grants an exclusive right for an invention, which is a product or a process that does something. It's got some sort of useful component to it. The most important thing to understand for our purposes is that to get a patent, you have to tell everyone the invention. So that's kind of the key takeaway. You apply for the patent and you have to describe exactly what the invention is, and then that invention is going to be published and everybody knows what the invention is. You get a limited term for the patent. You get your 20 years to be able to practice the patent, but in exchange for that, you're telling everyone what the invention is within that patent. And a patent, as it mentions at the bottom there, gives you the right to exclude others from making, using, offering to sell, selling, and importing. One key thing, which I think we'll touch on again later on, but I just want to sort of draw your attention to it. A lot of people think about intellectual property as giving someone the right to do something, but it's helpful to think about it in the inverse. Intellectual property gives you the right to stop other people from doing things. It's not that it gives you the right to do things. Okay, we'll touch on that again later, but that's really the difference between owning something and having a license to something. You don't need to own it to be able to do it, but you can sort of stop other people from doing it, and that's really the point. Trademarks, this one I imagine a lot of folks are fairly familiar with, and we're not going to spend too much time on it today, but trademark is any word, name, symbol, or device that's used to identify and distinguish goods to indicate the source of the goods. So, classic example, Coca-Cola on the side of a can tells you where that can came from. So that's kind of the difference. Now, a copyright, you can have a copyright in an image. I draw my little picture on a napkin here. It's going to be a great picture. Everyone's going to want to steal it, I'm certain. If I were to then stick that on a product and sort of try to use that to show everyone that, hey, this is Travis's product, then that image is covered by copyright, but it's then also functioning as a trademark. And finally, trade secrets, long definition there. The sort of boil it down. It's basically, it's information that the owner has taken reasonable measures to keep secret, and it derives independent economic value from not being generally known. So that's a key distinction from a patent, which I think we're going to talk through in a moment here, but the sort of key takeaway here is that a trade secret, you don't have to do anything to have a trade secret. It just exists. Just don't, you've got to try to protect it, but in terms of it coming into existence, just don't tell anyone is really kind of a key takeaway here, and that's the major distinction from a patent. And I think Jason was going to sort of chat through that, because I know that's a question that comes up very, very frequently for in-house counsel, is patents versus trademarks.
Yeah, so I think a pretty normal scenario that a lot of you guys might face in your business on the day-to-day is you get a super excited engineer or some product developer gives you a call and says, hey, I came up with something great. It's amazing. I want to get a patent because I want to get this certificate on my wall and get $1,000 under our patent incentive program. Can you call the patent lawyer and get us going? Now, you could say, sure, call the patent lawyer, get it going, and then just sort of hand it off and not do anything further from that. But it's always, I think for me, it's been helpful to sort of stop for a minute and ask, the very first question that you guys are asking on every commercial deal that you're working on, like, what's the value here? What's the commercial benefit here for our business on obtaining this patent? At the last company I was at, we had a large patent portfolio, but it was because the patent policy rewarded people for just generating patents. And they would get thousands of dollars just to generate as much stuff as possible, and no one ever sat and said, wait a minute, are we even going to use this thing? Does it make any sense? So what's the value? So asking that very basic commercial question of how are you guys going to commercialize this? What are we going to get back in return? On the patent side, hey, is this something that are we going to use this offensively? Do you want to have something that you can go after our competitors with? Or, man, our competitors are building a giant patent portfolio. Maybe I need to actually use this defensively and build this sort of moat around me of lots of patents that, hey, if you want to come after me, you're going to have to deal with my patents as well. So, there's lots of angles that you can look at from a value perspective in addition just to the dollars and cents. So just always ask that basic question, because you'll be just shocked at the number of times people will just do things just because they want to do it. And then, that's another place to add value, is to really look at, if you guys do have those programs, a lot of companies do, kind of rationalize those expenses to say, and go through that list, because when you pay for it, not only the application fees, the renewal fees, often you guys have global operations, so you're registering this all over the globe. But if you never sell that pump in Brazil, why are we spending thousands of dollars dealing with that? And that's an easy way for you guys to add value, improve the bottom line, and do something that I think can help sort of distinguish you as an attorney, even though you don't do IP stuff. Travis, anything on that you want to jump in on?
Yeah, no, I completely agree. The reality is, if you ask a patent prosecutor, can you get me a patent on this? They're going to say yes almost every time because it generates fees. It's just going to be a question of how narrow that patent is going to be and whether it's going to be of any use to you. A good patent attorney and one that you should work with more frequently is one who will say, yeah, but should you get a patent on this? Sometimes the answer is yes, right? If you're a startup, sometimes one of the first questions investors ask is, do you have patents? And sometimes it doesn't matter whether those patents are worth anything in the real world. They care about whether you have patents. So sometimes it's worth dropping 10 grand for a patent because, it's going to make your exit much easier. But as Jason mentioned, having a patent means filing the application fees, but then maintaining those patents. Every 5 years you're paying more fees, and again, it's only good in the one jurisdiction, and then you might have to do it globally, and then there's all sorts of issues that come with it. Sometimes it makes perfect sense. Sometimes it's frankly just not a very smart idea. So the key thing is, as I mentioned earlier, a patent gets disclosed. So after 20 years, there's some tips and tricks and ways to file continuations and do some interesting things, but sort of bottom line is that 20 years later that patent expires and everyone can go ahead and use that. The alternative approach is to just have a trade secret. So if it's something that the Coca-Cola recipe is the perfect example. How long's that been around? At the end of the day, if I can figure out what is in Coca-Cola, there's nothing stopping me from doing that. I could go and do that, and there'd be nothing, assuming I don't, break in and steal it. There's nothing stopping me from doing that. If your engineers or you, frankly, have come up with something that someone can't just look at and figure out what it is, maybe keeping it a trade secret makes sense. It's going to last longer. It's not going to cost anything to do. On the other hand, if you've made a new widget that is going to sit on the shelf and your competitor can just pick it up and look at it and figure out how it works, maybe a patent makes more sense, right? Because if someone can just figure it out, it's not much of a secret. So it really it depends on what you're looking at, and it depends on, strategic decisions, but those are the kinds of things you want to be thinking about. Don't just call the patent lawyer right away.
Yeah, on that, just to tie it off, I think lots of business people have heard of patents, at least have a sense of what that is and what it gives them. Lots of folks I've found, they have no concept of what a trade secret is. And so that is another avenue that is available to them to protect what they're wanting to do. And so I found it sort of educational when you're talking to executives sometimes, like, hey, you have these two paths, and here's the ways we can go at walking through the cost implications of it. And it seems like magic to them, but it's actually some very basic, straightforward concepts that I think you guys can take and apply to your day-to-day.
So moving on, IP-related issues in common commercial deals. I thought what might make sense is to chat through some of the deals that in-house lawyers face pretty frequently. Obviously these are I'm speaking to a fairly general audience here. If you are in-house counsel at a high-tech firm, then maybe you're doing the same deal over and over again, and some of this is going to be a little bit fundamental for you. Again, feel free to make a hasty exit. But these are the sorts of deals that in-house lawyers face pretty frequently, and I thought what might be helpful is to also chat through, from outside counsel's perspective, how the issues often get resolved. I find that if someone works in-house for the same company for a long time, they learn how that company deals with the issue, right? And one thing I've learned is that every client approaches things very differently. Some are quite aggressive, and some don't look very closely. So it can be helpful to know what's quote unquote market for some of these deals. Spoiler alert, it depends, like always. So common deals where IP issues abound. I'm not sure why I keep looking around there. I've got it right here on the screen. Master services agreements, those come up all the time. I think anyone who's negotiating contracts in an in-house context probably sees more of those than they want to see. Software license agreements, hosted agreements. For anyone who's not familiar, some of you may well be, but I get asked this a lot, kind of what's the difference between a software license and a hosted agreement? The simplest way to describe it is that in a hosted software agreement, often called cloud agreements, often called SaaS agreements, there are many flavors of them. But essentially what's happening is that the vendor is not giving you a piece of software for you to then install in your system and use within your system. What they're doing is they're providing a service that is online for you to log into and use. That's kind of a very baseline. As I said, there's lots of different flavors, but that's sort of it. Think Salesforce and that sort of thing, and hosted ERP software and stuff. So the key difference, as I said, is that you're not paying for a license under those agreements. What you're paying for is a service. You're paying them to keep the system running. So if it goes down, that's where a lot of the language in the contract kicks in.
Yeah, and I'll jump. I think this also confuses your business team sometimes because they're like, I thought I bought that software. Why can't I use it? Trying to think of like really good simple analogies. Like for me, often it's like, well, it's like getting a membership to a gym and buying some weights. Like I can buy the weights and we can install it in our house. I can use it forever, however long I want. I'm gonna have to go buy some upgrades or some different weights over time. Or we can get ourselves a membership to this gym and they'll take care of all that. They'll get new equipment in, they'll service it and all that sort of stuff. But I have to keep paying that on a monthly basis to get in and have access. And so then that, sort of those really basic, simple analogies can really make this simple, because once you start throwing those, AAS and all that sort of at people, they're like, what are you even talking about? So just thinking about, I think talking to guys like Travis and stuff, helping you break it down and really sort of explain that to your business teams, I found it to be incredibly helpful as well, just because these concepts get super confusing and muddled and clouded over that, and it just confuses your business folks, and sometimes they don't even realize what they're buying.
Yeah, that's a very frequent problem. No, thank you. That's actually a really good analogy. I am 100% going to steal that. So the next one is collaborative development agreements. I mean, obviously this, I think everyone in this room as a corporate lawyer knows it doesn't matter what you call a contract. So there's lots of different names. But essentially what we're talking about is just all manner of sort of collaborative development agreements, research agreements, university sponsorship agreements, joint development agreements. As I said, whatever title you want to choose. Then manufacturing and supply agreements, I think that one's fairly self-explanatory. And then, as I said, many combinations and variations. We're often doing joint development that then has a supply component and then, and then a license built into it, right? And then you've just got your basic M&A deals, right? So I think one of the main things we're going to talk about is ownership of IP in these commercial deals, and the reason I wanted to chat through this one is because very frequently I encounter deals that sort of stall out because both sides are the in-house lawyers are just being told, look, we have to own everything, and that's just the position. You always have to own everything, and at the end of the day, you can't all own everything, and it often doesn't. Sometimes it matters, sometimes it doesn't really matter. But what I want to do is give you the tools to kind of understand when it matters and when it doesn't matter. Sometimes it makes absolute sense that the customer should own it, and sometimes it doesn't. So as I mentioned there, so for services agreements, one of the things you want to think about is, if you're buying deliverables, are they custom, or is it really just kind of a, is the vendor really just taking their product and just, changing the name of it or slapping your logo on it or something and then giving it to you? Obviously, it sort of, if what we're talking about is the intellectual property, you're only going to be talking about what is developed in the course of that engagement. So if you're on the customer side and the business team wants to pay a vendor to take their existing product and tweak it in some way, no matter how much you fight under the agreement, you're only fighting about owning the tweaks. You're not going to own the background stuff that's built in there unless the vendor is really not paying attention. You're not going to take ownership of their background stuff. So the question becomes, what are you going to be able to do with the tweaks and only the tweaks if you don't have the underlying stuff? Maybe it makes perfect sense, right? In some contexts, if the tweaks are being developed based on your confidential proprietary information that you don't want your competitors getting their hands on, 100%, maybe it makes sense, right? The customer should own those tweaks. And another solid argument that carries the day pretty frequently is, hey, we're paying for those tweaks, we should own them, right? And frequently that gets the point across. Now, when the vendor is pushing back and saying, listen, we're tweaking this in the same way we do for every other customer, we're just making it work in a different system, we need to be able to do that again for other customers. In that setting, it probably makes more sense for the vendor to retain ownership. Again, this is all going to be very context specific, but the thing to keep in mind is that it's great if you can own everything. If the other side just falls over and says, yes, you can own everything, then great, the deal gets done. If you arrive at an impasse, it's just helpful to understand what it is you're actually fighting about and whether it's actually going to make a difference to you. Because at the end of the day, if the vendor retains ownership, but they give you a license to do anything you want with the tweaks, then you're covered, right? The only difference really between that and owning it is that if you own it, you can stop the vendor from using it again. And if it's an unimportant tweak, you might not care. If it's something that was based on your proprietary information, you might care. But again, that's that context, right? It's really a question about, as I mentioned earlier, owning it allows you to stop other people from using it. But if you just want to be able to use it, you can get a license, and that's probably going to be enough. So for hosted services, as I mentioned earlier, so that's the software as a service, SaaS, cloud, that's that context. In that context, generally speaking, the service provider is going to own improvements to their system and tweaks and things like that, and that's just, it's a practical reality because you're playing in their sandbox. If they're providing some sort of charts and data and analysis and things like that are sort of truly custom and really describe, if they were providing reports on, let's say, your company's usage patterns, data volumes and things like that, yeah, okay, you might want to own those, right? Because that's going to be important to you. But in terms of, if you're doing a contract with Salesforce and all they're doing is flipping on the switch and making it work with your system, that's technically, there's going to be some development involved in that, but there's no way they're going to let you own that, right? Because they're going to have to do that for everyone else. And at the end of the day, if you're on the customer side, practically speaking, what could you ever do with that little bit of code that enabled that platform to work with your system? Nothing. Once the agreement goes away, that's probably useless to you. The reason to own it might be, again, to keep it out of the hands of your competitors, or just to say, hey, we paid for it. Maybe that's a rational basis. But if you end up at a kind of butting heads phase, it's helpful to kind of take a step back and think, what are we actually going to do with that? Maybe it doesn't really matter.
I think on that point, what I've often found effective, sort of talking about that with our business teams, like, well, of course I want to stop company X from using it. They're our competitor. I wouldn't want them to do that. And then, you're sort of continuing to be at this impasse. This is sort of where you can kind of, if you pull in your litigation friends and then sort of, let me explain to you what say it's a patent issue, what a patent lawsuit will actually cost. How many hundreds of thousands of dollars or millions of dollars are you willing to spend on this code? Is it really worth it? And when you really sort of frame out, like, let's then play out that next step of ownership and what you can actually do, and then how you have to defend your rights. Oftentimes, once they see that price tag and the effort that goes along with that, and then potentially sort of collateral damage with your peers in your industry, they back off and you can help you get the deal done. But when you're sort of fighting at this and that kind of just from on a principles basis or something matter, sometimes you have a really hard time sort of getting the deal done. And that's another angle that I've used to kind of get us around this when it's like, okay, do you really mean that? Let's put some dollars to cents and would you actually sign your name to this demand letter? And if they're like, well, no, I don't really want to do that, then they don't really mean it. Mm-hmm. So just another sort of little tip that I've been able to use in order to get some of these deals done, because this is often a sticking point on work product and who owns it, and then what do you need to do with it?
Yep. And as with all these sorts of deals, that you're often dealing with a business person on the other side who has just been told we have to own everything, and they don't know anything about it, and they don't know why. So you've got to be able to explain it to a layman sometimes. So it's helpful to have that in your back pocket. So for collaborative development agreements, I get asked this one all the time, particularly in the context of university research agreements and things like that, and joint development. People ask, who typically owns the developed IP in this context? And again, it totally depends. There are lots and lots of ways to split this. In a university context, I often just find that the university wants to own it. That's because part of their mission is to commercialize inventions, right? They don't want to be out there just acting as a vendor that does research and just gives away the IP. What they want to do is they want to own it and commercialize it and teach on it and all those kinds of things. But in other contexts, it's frequently just a question of, hey, what makes most sense here? Again, right? As with everything else, leverage plays a big part. If you're representing, I don't know, Microsoft, you probably have a bit more leverage in the deal, right? Which is, it's going to be helpful, right? If you're on the other side of that deal, you're going to have less leverage. But the question often boils down to who's actually doing the work, who's putting in the money, and who is in the best position to commercialize these kinds of things, right? Sometimes it makes sense to form a joint venture entity, and then you can split ownership of that entity, and then you can have sort of governance processes for decision making and things like that, and distribution of profits, and maybe that makes sense. In some contexts, it just makes more sense to say, okay, well, we are two entities in two vastly different businesses, but we've decided that maybe our services and products work together in a way that could be cool. And I've worked on deals like that, and they basically just said, hey, if IP is developed in this industry, it goes to party A. And if the IP relates more closely to this other industry, it goes to party B. And if there's a dispute about which industry it more closely fits, then we have an arbitration process and things like that. Again, maybe that makes sense. Again, it's a context thing. I would just say the key thing to keep in mind is you've got to ask these questions and try to arrive at the answer that makes the most sense. Otherwise, this is the issue that really stalls out deals and often doesn't have to.
And so how does this pop up on the day-to-day? You're all like, we don't do joint research with state entities and universities. Well, you might be surprised that if, does your business team invite their MBA, the MBA alma mater to come in and work a case study? Does your data science team host a hackathon with the local university? And you start to then dig into these sort of moments like, oh, wait a minute, you're bringing in, so oftentimes, hey, we're bringing in these really smart guys from Wharton. They're going to deal with this really critical business issue. And you're like, hold on, like, what are you telling them about? And what are they doing? And what's the solution they're coming up with? And this really happens a ton with, sort of in the software community, they have a different sort of philosophy about, at least a lot of them do, this open source kind of philosophy where we're supposed to be giving back, everything should be available, everyone should be building on it, which is very sort of antithetical to how we view our IP, right? We want to protect it and keep it. And so there's a ton of activity going on with your business teams with MBA programs, with your technology teams, with local universities doing hackathons or other sort of similar type events that you may not even know about, and maybe you don't want to know about it, but these are other opportunities for y'all to maybe probe and ask some questions And it's not easy to get agreements done with universities, but there are ways you can get them done. And we've done at Southwest lots of deals with lots of local universities where you can protect your IP, and dealing with the students and the professor and all that. So it can be done. It can protect it. There's lots of ways you can kind of do some practical mitigations around it as well. So don't think that, just because I don't work at a software company or I don't work at an R&D kind of focused business that this isn't happening. If you're a big enough business, it probably is going on and no one's told you about it. So something worth investigating.
Yeah, and it's, as I mentioned earlier, I mean, these agreements can have lots of different names. I've worked on a number of them recently where it's a business team has decided to bring in a branding company and they call it sort of a branding collaboration, and they just, they want to have an agreement that says the parties will jointly own the IP, and in that situation, frankly, that's probably not a very good idea, just because it's your brand, right? You don't really want the brand agency being able to use it and give it to other people. But so, again, it doesn't have to be called an R&D agreement or a joint venture agreement or what have you. It's just if you've got an agreement where, there's provisions in there saying, look, the parties will jointly own, then you want to have a closer look, because that raises some issues. Licenses, yeah, that's right. So just a real quick slide here. I don't think we need to spend a bunch of time on it. I believe this is all, you'll be able to get this presentation afterwards, so really this should just be a resource going forward. There are certain exclusive rights that these various types of IP provide, more so on the copyright and patent side in terms of what's listed in the statutes. But this gives you a bit of a guide on what it is the ownership of the IP is allowing you to exclude others from doing. That was quite a lengthy sentence. These are the exclusive rights that you can grant to another party in a license, or you can choose not to grant, frankly. I see all the time in software agreements a license to use software, which doesn't have any statutory basis. At the end of the day, I think anybody reading the contract sort of implies or infers what that is intended to mean, but realistically it should be written as, hereby grants a license to reproduce, distribute, prepare derivative works, what have you. And these are key. There are key differences between these. In some deals, it makes perfect sense to say, okay, we're going to license you our software for you to use internally. I'm going to use internally. But we're not going to let you distribute the software, right? It makes perfect sense. These rights can be split out, right? It's a bundle of rights that can be separated depending on the context. Same thing with patents. Same thing with each of them. The point here is that if you are on the licensor side, if you own the IP, then you can grant, you can tailor the scope of the license to fit exactly what the licensee needs and nothing more than that. If you're on the licensee side, as long as you have a license grant that lets you do everything that you intend to do, then, you may well be fine. That's really the point. So often overlooked issues on ownership. We've talked about, the sort of battle you can have on let's say an MSA, work product, trying to take ownership. Some other issues that come up in that, background IP, people often forget about that. The example I gave earlier is if you're buying a deliverable from a service provider and you're fighting about work product, it's only the thing that they're creating. If they're giving you a piece of code, they may be creating it from scratch, probably not. If you've ever worked with any software developers, they're probably pulling it from a drawer somewhere. You don't want them to be doing it, and you want your contract to prohibit them from doing it, but it often happens, right? So you need to make sure on the customer side that you're not only getting either ownership or a license to what is developed, you need to have the right to use any existing stuff that is included in that deliverable as well. And you'll often have some of the agreements we work on, you'll see language in there that says the vendor is also granting a license under any patents that it owns that might happen to read onto deliverables. And the point is, if you're a large company who faces a lot of patent troll lawsuits and things like that, you want to make sure that, this is not a setup, right? Getting a license to the copyright in the code isn't necessarily enough. You want to make sure that you're completely covered. It's a defensive strategy, not an offensive strategy. Second, this one comes up a lot. You need to make sure, from the customer side, you want to make sure that the vendor has to have its agreements in place with its personnel to actually get you these rights. This happens all the time. Sometimes in the M&A context, what happens is you get to the point of doing diligence and the seller's counsel says, yeah, we own all the IP. And you say, okay, well, show me the contracts with your personnel, or at least rep that you have those agreements in place, and they don't have any. It doesn't matter whether you intended to own the IP. If you don't own it, you don't own it. That's just kind of how it goes.
On a practical point, so what we mentioned earlier, hey, maybe it's a software code. You might then have an argument to say, we got a copyright and I don't need one. But if it's a patent issue, if you didn't actually get an assignment from your inventor, you might have some problems. I don't know, Travis, if you want to dig into that. I think that's a good where that is a distinction there where if you guys don't have invention assignment agreements that you roll out to people when they onboard and it's part of their packet, they're signing everything anyways, a disclosure process for prior owned things, that's another area where you can add value and prevent a problem down the line when you're especially if you're in a situation where you're looking to exit or sell your business or whatever. So that might be worth digging into a little bit. Like where can you, if you don't have that document, what happens? What's
I mean, so again, as Jason mentioned, it depends on the IP, right? So copyright has a great little default under the law that I'm sure anybody who's negotiated a contract has seen, there's language that says a work product is a work made for hire to the extent permitted under applicable law, right? And people just kind of look at that and say, okay, well, that's in all the contracts, so I guess I know what that means. So this is the actual language. If it's prepared by an employee within the scope of his or her employment, so, you hire a software developer and they work for you and they develop software, the copyright in that software is going to be owned by that company, and that's great. Outside of that context, or even if there is a possibility that it's outside the scope of their employment, they're taking on a different task or something, bottom line, there's no reason to gamble on that. You want to have assignment language from them. So that's, as Jason mentioned, if you don't already have IP assignments in the onboarding documents, you definitely want to get those in place because, as I said, it comes up all the time in the context of an exit where it just turns out the company doesn't actually own the IP it thought it did. And, sometimes it's unimportant. Sometimes it was just, hey, they didn't have everyone sign, but hey, the key developers signed, so it's okay. Sometimes it's one of the founders, and then they have a falling out, and that founder just splits, starts their own company, and that's just, tough. You don't own the IP.
Yeah, and then the key there is that this is where you then get tripped up potentially, is within the scope of his or her employment. So some people in your company, that's their job. It makes a ton of sense for them to develop IP, write code, do whatever. There's some other folks in your company where that may actually not really be part of their job. What if they're just in a different group, but they came up with this phenomenal idea, and you think you should own it. And well, now say you didn't do the agreement, you might be in a little bit of a tussle, especially if that employee decides, well, I came up with this. It's not part of my job. I should be able to go out and start my own company. It's a phenomenal whatever. And so that's why, why we have a backup argument on the copyright side. It still makes a ton of sense, even though you want the document for patents, but you may also want it from the copyright part of it, because you don't want to have to even deal with that argument back from that employee. Well, that's not part of my job, or I did this on my own time, quote unquote. Mm-hmm. And then now you're having to sort of run through all those issues. And, I think it comes up, it's something that can come up quite often, but if you put in that onboarding packet, signed off, then you can take care of a headache, I think, for a lot of your business teams.
Yep. And on the customer side, when you're doing, say, the MSA or the whatever agreement where you're trying to take ownership of some IP, you basically just want to hit it, as I mentioned on the slide there, with a multi-pronged approach. Yes, you'll say, okay, customer will own all the work product. That's great. You also want to have language in there saying that the personnel will get those rights from its employees, right? You also want to add in that you might require the vendor to report to the customer that IP has been developed. You might prohibit them from bringing in any third-party IP or using their own IP without getting consent, because you want to be able to rebut that argument later and say, well, no, your IP is not in there. This is all of our IP. You would also add in that, with sort of typical assignment language, that you can require the vendor and its personnel to execute additional documents. If you're filing a patent application and you need them to sign something, they should be forced to do it. And you can also give the customer the right to sign those documents on their behalf if they won't. So again, I think we're sort of falling a bit behind on time, so we'll move a bit more quickly. But the point here is that it's not just a matter of having one sentence that says customer shall own. Just as an aside, don't say customer shall own. That doesn't get you anywhere. Vendor hereby assigns. Make sure, hereby assigns, key. So moving to a couple of other areas in general contracts, reps and warranties. As relates to IP issues in particular, fairly standard one. You want to make sure the vendor has all the rights necessary to grant the rights. If they're granting a license, they need to have the rights to do that, and if they don't have those rights, you want to be able to go after them, right? They're repping that they can do it. As far as development work, you can have them represent and warrant that what they're developing for you is original to them, or otherwise doesn't infringe a third party's IP. I frequently deal with vendors who will say, we don't want to represent and warrant that our work does not infringe someone's IP. They will indemnify, but they don't want to rep and warrant because they don't want to be sued for breach as well as an indemnity. Obviously, there's ways to resolve that in both ways. You can make the indemnity the exclusive remedy. You can do all sorts of things. But that's something that comes up pretty frequently. Yep.
Could you explain why there's more risk to taking on rep and warranty versus indemnifying?
Yeah, so the question was to explain why there's more risk in taking on a rep and warranty as opposed to just indemnifying. The point is that if you're required to indemnify under the contract, then you'll be responsible for covering the costs incurred by the customer from the third party claim. If the vendor also represents and warrants that the materials don't infringe, the concern is that the customer will not only seek an indemnity, they'll just sue them for breaching the contract as well. So effectively, the vendor will have to indemnify the customer against all of those costs, but also potentially have to pay damages just for breaching the contract. That's the concern. So again, there's ways to deal with it. Vendors will often just say, okay, fine, we'll do it, but we'll say, they'll insert some language at the end of the indemnity that says this is the sole and exclusive remedy for any IP claims, and they'll try to sort of cut it off that way. Important on the rep and warranty and the indemnity, you want to make sure that it covers the customer's use of the developed IP, not just the IP itself. That one gets missed all the time. Moving to the indemnities, again, customer's use. Indemnities get carved out. I won't spend a bunch of time talking through these various bullets here, but really the point is these are common carve-outs. I've bracketed in some language that frequently get negotiated on these IP indemnities. The point is that vendors will say, okay, we'll indemnify you against claims, but here's how we're going to limit those claims. It's only going to be for patents. It's only going to be for copyrights, or it's only for US-based IP. There's lots of ways of sort of pulling levers to find a way to appropriately allocate that risk. and the vendors will often carve out these exceptions, which I mentioned there. If the customer modifies it, well, yeah, okay, we're not covering that if the claim arises out of your modification. Or, if we developed it based on customer specs, then, hey, if the claim wouldn't have arisen but for our compliance with the customer specs, then, we're not going to indemnify. So those are some common ones. And then I think finally, I think this might be the last slide or second last. Again, a couple more carve-outs. You'll normally see some specific remedies included in the agreement. And this is really just to protect the vendor, to be able to say, hey, look, we need to be able to resolve an IP claim. We need the flexibility to do it, whether that's negotiating a license or, hey, if we have to modify the deliverable, we can do it. This is just sort of allows vendors to deal with the IP claim. So you'll be able to use this reference later. And then just finally, just to note, for anybody who doesn't know, IP indemnities often carved out of limitations of liability. So from the vendor side, this is one to really, really keep a close eye on. This is where it's important to have your developers on a tight leash, making sure they're not reusing code, copying code, things like that. And if you can get an enhanced damages cap, well done, push for it. You'll often see these be unlimited liability. But again, many levers to pull to reach a compromise. So I think that's it from me, Jason.
All right, well, thank you guys so much for us.
Yeah,
And
thank you.
find us afterwards.